Good afternoon.
Good afternoon, sir.
My name's Ivan Tamarkin. I've been doing landlord-tenant law probably about 51 years. I helped write the new landlord-tenant law. Back in 1970, I was attorney for the Model Cities program under the Great Society, Johnson's program. And I was one of the only lawyers living in the Model Cities area. So the city of Cincinnati hired me to represent the residents of the West End, over the Rhine, and Mount Auburn. I lived in Mount Auburn, and my office was in the Alms Hotel building. I had an office downtown too, but basically I started representing people against companies, and when I was requested, asked to give this talk, I slanted this, as you can see, mostly for tenants, not for landlords. So I'm not sure, can I get a show of hands? How many landlords are here? So basically, there's more landlords than there are tenants. So I'm going to probably follow the outline, but I've represented several landlords as well. But I probably represent more tenants as a private attorney than anybody else in town. I represent a lot of tenants. Tenants, legal aid won't take too many fee cases. They're so swamped that they don't like to take breach of warranty of habitability cases. Legal aid doesn't like to take a lot of cases where attorney's fees can be generated. So I probably have 4 jury trials coming up where I represent tenants. In any event, I slanted this, as you can see, if you follow the outline. It says before leasing, what should a tenant do? Well, for those of you who are tenants, you should follow this outline. And for those of you who are landlords, I would suggest that you look at the statute. I have had at least 2 cases where I've had judges in Hamilton County throw the lease out because the lease was unconscionable. That is not part of the outline. I'm talking to landlords now. If your lease has provisions in it which are not codified or not part of the law, like if your lease has that you can get attorney's fees and the tenant has to pay them because you're filing an eviction, that's an unconscionable clause. The statute says you cannot get attorney's fees just for an eviction. If your lease has that the tenant is required to make all kinds of repairs to heating, to air conditioning, to do all kinds of things, which is the obligation of the landlord under 5321.04. And if you read 5321.04 of the statute, the landlord has all these obligations. And if you put in your lease that some of these requirements are going to be for the tenant and not the landlord, then a municipal court judge may say your lease is unconscionable, throw the lease out, and therefore your lease isn't, the lease is not any good. And I've had a couple of judges do that. So, yes?
So what does that mean? I bought a building.
Okay.
I got the lease. I didn't want the lease.
You're a tenant or a landlord?
I'm a landlord.
Okay, you bought the building, and
I bought the building and I bought the lease.
there's a lease pending. When you buy the building, there's a lease. You have to honor the lease.
Right.
Right.
So the lease says exactly what you just said.
Well, then you should prepare a new lease and talk to the tenant. You should prepare a new lease and say, you can do that. You can ask the tenant to sign a new lease which complies with the law.
Okay.
I wouldn't want you to take that lease.
I didn't think that was right.
Okay?
They don't know what they're doing.
Well then,
And they might have Jack Frost come in and
Right.
do something that
Right.
he don't know what he's doing.
right, so, or you can just go on a month-to-month, or you could prepare a new lease and have it comply with what the statute says. In any event, I've written down a bunch of things for a tenant, for those who you are tenants. You should try to do these before you rent an apartment. And you should ask the certain questions that I've written down in there. The statute says that a landlord must give an address. They must tell who, they must give a copy of the lease to the tenant. If they don't, it can be unenforceable. A judge in Hamilton County can say it's not enforceable because the landlord has not given a copy of the lease to the tenant. And if you don't give an address, now I've put in here some of the things that I suggested that the tenant do. Does the landlord have to give all the answers to these questions? Probably not. Probably they don't have to. They probably don't have to say who owns the LLC. They probably don't have to say who are the partners. But if I'm representing a tenant, I'm going to tell the tenant to ask those questions because they want to know who's behind the LLC. They want to know who's really managing the property and who's taking care of it. They don't want to be just subject to a corporation. So if you represent if you're a tenant, that's the kind of questions you should ask. And if you have a disability and you're a tenant, you should definitely make sure that you tell that disability to the landlord. Now, as landlords, each of you should look and make sure that you're aware of the disability laws, because there's a lot of cases now before the Ohio Civil Rights Commission about pets. That's a big topic right now. If a tenant has some kind of problem, medical, emotional, they can have a service dog. And if they have a service dog and you've got 4 units, you've got to rent to them. If you don't rent to them, they can file a charge with the Ohio Civil Rights Commission and they can get damages, and under the national statute they can get punitive damages and legal fees. And I can tell you, years ago when Bob Loftman was doing this, I was involved in a case with Bob. He got only $1 because there was not many damages, but his attorney fees back then, this is 35 years ago, he got $6,000. Today that would be $30,000. So you got to be worried about violating the housing civil rights laws as a landlord. If if the landlords, you're familiar with HOME, you're familiar with the Ohio Civil Rights Commission, and HOME is pretty active, and they're going to make sure that you don't discriminate on the basis of sex, race, age, disability, children. The statute all covers that. And I've represented both landlords and tenants before the Ohio Civil Rights Commission, have several cases pending. So if the tenant asked you the question, though, the tenant asked you these questions, and the tenant says, I want to have a pet, I want to have a pet cat, I want to have a pet dog, ask them for a doctor's statement for your landlord. Ask them to see a doctor's statement. Ask them to see if they're certified. Do your homework, but don't immediately say, no pets. You can have no pets in the lease, but you're going to have to make an exception. And if you have more than 1 unit, maybe you can have 1 unit where they'll take pets, and 1 unit where you don't have pets because there's no grass, there's no place to take the animal. So you should be aware of the fact that you must accommodate that, and it doesn't need to have the tenant doesn't have to be certifiedly disabled. All they have to have is a letter from a psychologist or a doctor. And if they have a letter that says that they need an emotional support animal, you're going to have a problem if you don't rent to them. Yes?
So, based on what you say, the sentence "no pet" is illegal. I should not have.
Well, I think you should, in your leases, I wouldn't put, you can put in that clause that it's not, you can put in the clause that you discourage pets, but I wouldn't put no pets. I'd put in the you discourage, but I would have, you have more than one unit, then you could have pets in the other unit. But the no pet clause can get you into trouble today.
Yeah,
So,
I have 10 units, and my general lease is no pet.
well, that's a tough question, because if you put that in, and Home sends some checkers out there, which they might do, housing opportunities made equal, if you have a lot of units, they may just set you up for that. So I would put in that I wouldn't put in all your leases that you can say you accommodate pets if it's necessary for a service dog. You can put that in the lease. Now, there's very few people who have service dogs, but there are people who have them. So,
in branches except service dogs or something?
right. No pets except service pets. Right. You can put that in the lease. Yes.
And can you charge them?
Well, I haven't seen any cases on that, but if you charge them, I'm sure Home's going to take the position that that's discriminatory,
Like
because
$50.
you can charge that. You can have a pet charge.
Right.
You can have a pet charge and say that, okay, but you're going to have. But I'm sure the Home is going to take the position that that's discriminatory against the service dog, because then you're treating the disabled who need that dog differently than you are a tenant that doesn't need that dog.
Okay.
So I would put in, you can have pets, but you can charge. But if it's a service dog, there's no charge.
But can you say you can have pet, but when it comes time to get your deposit back, there will be X amount of dollars deducted for the pet?
You can't say that unless you have an exclusion for service dogs.
Oh.
Yes.
If they have service dog,
Right.
does they have to present the doctor's recommendation or something like that? How would we know that this dog
You
is
can request from them a statement from their physician or the psychologist or a therapist that they need the service dog, right? Because
we can state it in the
you can request that.
Yeah.
They don't have one, they can't get it. You can say, well, I need that. You can't tell me. Yes, you can request that. That's reasonable to request that. So some of the things, and most of you are landlords, so do you want to answer all these questions? Well, I don't know if you have to answer them all. The tenant's going to ask, but if you're a tenant and you're here, I would ask all these questions, because I would take pictures. I would ask who the prior tenant was. I'd make sure about the lease, and I'd make sure I get a copy. Make sure all the appliances are in good order. And of course, there's always the issue about pest controls. There's always the issue about rental insurance. The issues, do you have in your lease that the tenant must take out rental insurance? If you're landlords, I suggest you do that. Because even though you're not responsible generally for items that get damaged, you are responsible if there's no electric, if there's no heat. You're responsible for all those utilities, responsible to furnish all that. You're generally not responsible for damages to furniture, but it's a good thing to put in your lease to tell the tenant they must get rental insurance. That way they will be able to collect on their furniture. So I'm going to move on. Most tenants do not, if you're a tenant here, most of you think, well, you know, I'm behind in my rent, so the landlord they'll work with me. They'll work with me. The landlord doesn't have to work with anybody, except if you've established a pattern. Now, if you've established a pattern, you're taking rent late, and a pattern can be 2 or 3 times. One time, probably not. But 2 or 3 times you've established a pattern. So the rent is due on the 2nd, but you don't take it to the 6th or the 7th or the 8th, and you've done that for 3 months, and you don't like this tenant, you want to put the tenant out. And the tenant offers you the rent on the 7th, you're going to lose that eviction because you've established a pattern. If the tenant can prove you've established a pattern, then the case law says that you cannot obtain an eviction if you've established that pattern. So, but for the tenants that are here, you can't just say, I'm not going to pay the rent, I'm going to pay it late, and the landlord will accept it. If you're late in your rent, they can evict you unless they've established a pattern. They don't have to accept the rent. They can send it back to you, they can evict you, there'll be an eviction on your record. Most tenants don't want an eviction on your record. So what do? So you're a tenant and the building needs repairs. And you complain and you complain and you complain, and the landlord doesn't fix anything. And you do emails and you text and you write and you've called the health department, you call the building department, nothing happens. So if it's very serious, you as a tenant can escrow your rent. You don't have to give the 30 days. If it's not serious, you've got to give the 30. The statute doesn't say anything about 30 days. The courts have interpreted sort of 30 days, but doesn't say that. So if you're not getting any heat, and you're complaining to the landlord, and the landlord doesn't give you any heat for 10 days, and it's the middle of the week, put your money in the escrow. But if you just don't pay the rent, and you don't put it in escrow, and you don't give them the 30-day notice, landlord's going to evict you. Yes?
Could non-payment of rent also be considered like a pattern? Like if a tenant doesn't pay the rent for about 2 to 3 months, and then you can go to evict him, whatever. So if you evict him after the first month, so he doesn't look at it as a pattern, and you accept the non-payment?
I don't think a court's going to, no. I don't think a court's going to, non-payment of rent itself, no. A court's not going to establish that as a pattern.
Okay.
If you're not paying your rent, that's not a pattern. The landlord can evict you, especially if you're 4 months in behind. That's not a pattern, no.
Okay.
Pattern is if you accept rent late, then you can't evict. But if the tenant has been there and not paid the rent at all, most of our magistrates are going to put that tenant out.
So I inherit the lease. The tenant follows the lease, paying 5 days late. I don't want my rent 5 days after.
Well, what do you have to do then? You have to send them a notice.
I did.
Send them a new notice that says, I will not accept the rent late again. I won't do it. And I won't do it. And if you do that, and you make sure you keep a copy and you show it to the magistrate or the judge, and the tenant's late, you can send the rent back and the eviction will be okay. You can change that pattern.
It's not the law though, right?
It's the way that I can tell you, practically speaking, these are court decisions. I can
Right.
tell you the magistrates in Hamilton County, and I don't do much outside of Hamilton County anymore because I'm too old to travel. I don't want to do that anymore. I used to go to Butler and Warren, and I don't do that. But the magistrates in Hamilton County, if you send a letter that says, I've established a pattern, but I've not doing it, your next rent has to be on time.
Yeah.
Then you can put the tenant out if they're late. You got to prove that you served that notice on the tenant.
Okay.
Now, let's talk about issues regarding the evictions, okay, and jury demands. Somebody else, you want to hand this back? So what happens? What happens if you, yes, you have a question?
I didn't get any.
Oh, okay. Well, then, let's see. Generally, if you're a tenant and you come in and you think that you'll get a continuance, these magistrates will not give you a continuance if you're behind in your rent. They might give you a continuance if you're current in your rent and the landlord is trying to put you out with a 30-day notice. They'll give you a continuance to get an attorney. But generally speaking, so if you're a tenant and you want to go to a lawyer first, because if I appear with you, I'll get a continuance. But the tenant itself will not get a continuance if they're behind in their rent. Now, if they're current in their rent, then you're putting them out for 30-day notice, violation of the lease. They'll generally give these magistrates will generally give the tenant a continuance.
In what case the tenant can refer to the jury and it takes long time?
Well, that's what I represent, a lot of tenants, so I request juries all the time.
Yeah,
So what do you do if you're a landlord?
yeah.
You can try to get your lawyer to get the judge to move as fast as they can.
Based on what you can just ask the jury, based on what ground?
That's part of the statute says you have a right to request a jury. In any civil case, you can request a jury.
Oh, okay.
Yes.
And when you request the juries, it takes long.
It takes a long time because magistrates can't hear jury trials, only judges. So if the tenant requests a jury, they're going to, and they keep on paying their rent in the courts, so you're protected. When the tenant requests a jury, you as a landlord are going to request a bond, and that bond is usually 1 month's rent. And if the tenant continues to pay the rent on time, the tenant may be there for 5 months before the judge will set a jury trial. So judges don't like to hear jury trials. They despise them. I mean, it's a lot of time, it's a lot of work for these judges. I know all these judges. I've got 3 jury trials scheduled for tenants. All right? They don't want them, so they usually settle because it's too expensive for all the lawyers, it's too expensive for the landlord, too expensive for the tenant, too much time for the judge, and they usually settle out most of the time. But they don't always settle, and the big thing that you as landlords have to worry about, obviously, is not basically what the tenant's going to get. You've got to worry about attorney's fees, because the court will pay attorney's fees in a retaliation case. And most tenant lawyers will allege retaliation, some form of retaliation. And if the jury finds there's retaliation, even if they only finds the retaliation is worth $200, the attorney is entitled to attorney's fees. And I can tell you that myself and about 3 other attorneys in town who know landlord-tenant, the court's paying us $400 an hour. So you can get stuck with, I've gotten attorney's fees of over $10,000 before. So you can get stuck with attorney's fees. You don't want to do that. As a landlord, if you've got some liability, if you've retaliated, your best bet is to settle these cases quickly, not to go to trial. Because you go to trial, that attorney is going to spend a lot more time. Going to trial itself, you could spend 40 hours going to a jury trial easily. All the jury instructions, everything you've got to do. So you want to settle these cases pretty quickly as a landlord.
The landlord cannot represent themselves?
Of course they can, but they're not going to win generally. Generally they can, but they're not going to win. You don't know the rules of evidence. You don't know the objections. You know, you haven't gone to law school. You can represent yourself, but you're not going to do it. I'm going to try and move on. We'll wait to the questions later because I've got a lot to cover here and too many, and we got 35 minutes. So I've suggested things regarding a jury trial here. To get a jury trial, the tenant's got to put up, when they file their answer and counterclaim, they only have to put up $10. So it's pretty easy. Most tenants have $10. That's all they have to do is file an answer and put up $10. But 2 weeks before the trial, they've got to put up $300. And a lot of tenants don't have that. So if they don't put the $300 up, you file a motion to exclude the jury. If you don't have a jury, the case will go for a couple hours and the judge will find what he wants to find. Maybe longer. But you get a jury, you're going to have 3 days at a minimum, because the municipal court judges only hear cases in the afternoon. So you're coming at 1 o'clock, and the next day, and maybe he's got a criminal case, and then it's continued for a week. And meanwhile, the tenant is sitting there in the apartment. Of course, they're paying their rent. It's not like the rent's not there. The rent's in escrow. If the tenant doesn't put the rent in escrow, you evict him. That's the order. So then they got to put up $300. And the tenant has to continue to pay the money into escrow. If they don't put the money into escrow while they're living there, then you can ask the court for an immediate eviction. Some judges will give immediate eviction, some won't. Some judges are tenant friendly, some judges are landlord friendly. And I've had judges say, oh, come on, he was only 3 days late with the rent. It's in escrow. You're not losing anything as a landlord. We're going to a jury trial. Settle this. That's what they're going to say. All the judges are going to. Yes, ma'am.
Is this your name on here, sir?
Yes, it is.
Is that your number?
Yes, it is.
If we have questions after this class, are we able to call? Because I have to go through all the stuff that happened.
Well, you can have questions, but I charge an hourly rate, ma'am. I'm not legal aid, so I don't answer questions. I've been doing this for 51 years, so I charge a fee. I'll give advice on the phone for a few minutes, but I'm not going to spend time on the phone with people because I charge a reasonable rate. So, yes, I'll be glad to give you advice, but I do charge a fee.
But you'll answer a few questions for free?
Very little. I spend less than 5 minutes on the phone.
Okay.
I can't do that and make a living. I've got staff. I don't do that anymore. I did when I was a young lawyer. I don't need to do that now. So I charge a reasonable fee. I don't charge $400 an hour to clients, believe me.
What's your fee, sir?
$180 an hour.
$180.
For a landlord-tenant trial, $300 an hour. Going to jury trial, that's different. Different. Trial's different. Advice, doing an eviction, that's pretty easy stuff. That doesn't take, I could do that in my sleep. Going to a jury trial, that's tough. Jury trials are, that's a lot of work. So, breach of the warranty of habitability. Is there anything in the statute about that? No. That's common law. The landlord under 5321.04 has all these duties. And if you don't keep the apartment up, if you don't paint it, if the tenant makes a lot of complaints all the time and you're not doing anything, and you try to, and I've got 2 or 3 cases now where I have counterclaims, jury trial, and I'm asking for breach of the warranty of habitability. I want some of my rent back. I've paid the rent, but the landlord hasn't. I just got through trying a case a couple days ago. The backyard, the whole time there, was full of water. Landlord never fixed it. I'll get some of the rent back, not all of it. Judges aren't going to give a tenant all the rent back. They're going to give some of it back. because the landlord has breached the warranty of habitability. Tenant is paying $500 a month, wants to use the backyard. The backyard is a pool of water, and the landlord doesn't fix it. The air conditioning doesn't work for a month, 2 months. Tenant is entitled to some money back. The heat doesn't work for a month. Now, if you repair things quickly, then there's no breach of warranty of habitability after you've been notified. But there are cases where most of these things settle out. They don't go to trial, but some of them go to trial. And I've listed all the landlord's obligations, which I think are the main ones, in section number 5. So I'm not going to go through those. Number 6 on page 4 is mainly for tenants, but the tenant decides to bring a roommate in, not on the lease. And tenant is paying the rent, but the tenant is, pushing dope, pushing drugs. So you want to put him out. So you, first of all, get a police report, go to the police, check it out, and then give them drugs. You give them a 3-day notice. You don't need a 30-day notice for drugs, but you're going to need to show you filed that police report, and you're going to need a policeman there to get them out. What about the roommate? The roommate's not a tenant. So you just can't file an eviction to get that. You're going to have to go criminal trespass to get that, or you're going to have to give them a 30-day notice that they're there illegally, and give them a 3-day notice to get that roommate out. Does the roommate owe for rent? Yeah, but the roommate doesn't have any money. So so you're stuck, right? Because the roommate has no money. You got a security deposit, but you got some problems, so you're going to have to do what you can. If they're pushing drugs, you can go to the police, go to the sheriff, try to get the roommate out that way, or you can file another eviction action against the roommate, but the roommate's not responsible for rent because you don't have a contract with. But you've got a claim for unjust enrichment. Yes?
As a landlord, what could you do if you suspect someone else living in the apartment that's not on the lease, but the tenants say that they're just visiting? And that's their claim, that they just
Well,
visit.
and that happens all the time. It's not, it's hard for the landlord to prove that, but you've got to prove that that's not a visitor. That's your burden, and that's really tough to do, because what are you going to need, a camera? And they're going to testify they're just visiting. They're allowed to visit. You can put in your lease, can't have visitors for more than 3 weeks. I think that's reasonable. You can put that in. If somebody's there for more than 3 weeks, I'm going to consider that person a tenant, and your rent's going to go up. You can put that in the lease. I don't think that's unconscionable. There's no statute that says it's not, so you could do that. And that's a way to handle that. But it's tough to get, it's a tough question. It's very difficult to prove that, since it happens all the time. A lot of tenants will bring their friends in and they'll live there. And to prove that they're there, is it a violation of the lease? Most landlords will put that's a violation of the lease. You can't have somebody there living there you put a time frame in. Then you can give the tenant a 30-day notice and get everybody out. Yes. Yeah.
Like in a case where a tenant moves out in the middle of a lease, but they kind of move somebody else in and let them live there as well. Do you follow the same procedure as giving that person the eviction 30-day notice? And then also, what happens to the original tenant that moved out in the middle of the lease and then just moved somebody else in?
Well, the original tenant is liable for the rent because they've breached the lease.
Right.
No. The person they moved in is not on the lease, but it's a trespasser. They're not on the lease. If the tenant is moved out, I'd go to the police first and say, somebody's living there, and they have a right to be there, they're trespassing. All right? That's what I would do. I would go to the police and see if the police usually say it's a civil case, we don't want to get involved. That's what they're going to tell you. It's a civil case, they should get involved, but they don't want to get involved. So what you want to, so then you're going to have to go to the, so you have to give an eviction notice, you have to say they're trespassing, they're not paying rent, give them a 3-day notice and put them out. But I try the police first. You know, that's all I can tell you to do. I can't tell you to go in there and, you know, literally throw them out, because that just runs into a lot of bad, you could get sued for that. You don't want to do that. Years ago, I remember I did that. I think I represented F&H services in Mount Auburn Good Health. We had a lot of tenants do that, and I wouldn't tell them to do it, but they would go in and just remove the tenant, put the stuff on the street. That's what they would do, and they weren't a tenant, so they didn't have a cause of action. So you run some risk there. You run some risk of disorderly conduct. You run some risk the police are going to get involved, but that's a risk that you're going to take. You could take that risk if you want to, as a landlord. I mean, you could take that risk if you want to. But there's a risk that you're going to, the police are going to get there, and the tenant's going to start a fight, and somebody's going to get hurt. So generally the police don't want to get involved in these things. They're too busy with other kinds of things. Yes, ma'am?
I had two situations.
Well, but for personal things, we're going to do that afterward. You can talk to me afterward. Yeah. But the general question, you weren't here when we did the... Oh, you need one of these? I'm sorry.
Thank you.
Now, let's go to... I don't do a lot of federal... I don't do a lot of Section 8 work. But just a warning to you as landlords and as tenants, a 3-day notice is not sufficient in subsidized and Section 8 housing. You need a 10-day notice at least. In some leases that are subsidized in the 236 projects, you need a 30-day notice. You have to look at where you're getting your money from. You have to look at the Section 8. You have to look at all that. But if you don't give those proper notices, the courts are not going to issue an eviction. So a 3-day notice is not good in subsidized or Section 8 housing, and you've got to serve CMHA, give them a copy of that, or if it's some other subsidy, you got to make sure that they're put on notice. Well, just hold. I wanted to get into security deposits. It's a pretty clear, but there's a lot of cases on security deposits. So as a landlord, you have some obligations, and if you don't give that security deposit back after you've been served with a written notice of the address of where that tenant lives, and you don't give the security deposit back, or you don't give something in writing to the tenant that says what you deducted for, with estimates of what the damages are, maybe. If you don't do that, you don't do it within 30 days after you get the written notice, you can be sued for double the amount of the security deposit plus fees. And again, fees are going to... You get some young attorney at Dinsmore who's doing this for a VLP, and they do them. You know, Taft, Dinsmore, Frost, they all these young lawyers. They do volunteer lawyers for the poor, and they represent a lot of tenants. And they give that money back to the VLP, but they do it a lot. And I do it. I don't work for a big firm, but the big firms want their lawyers to do a lot of pro bono work. So volunteer lawyers for the poor, people go to legal aid. Legal aid doesn't like to try cases. They don't have staff to do it. So they go to volunteer lawyers for the poor, and they send out to these different attorneys with the big firms. And if you're just out of law school and you're with Dinsmore, you don't take a VLP case, you better take it. They may not keep you So you're going to take it, you know. If you're too busy, they want to do a lot of charity work. They want to get the press. So you got to worry about security deposits. Now, this the Supreme Court has found, though, that even if you don't send the security deposit back and you don't comply with the law, if the tenant goes to court and the damages to the apartment are more than the security deposit, the tenant gets nothing. Double or nothing is nothing. And no attorney's fees either. So, while you should comply with the law, if the apartment's really bad and you take pictures and you get estimates and the judge finds that the tenant is not entitled to any money, even though you haven't given the 30-day notice, and even if you as a landlord have not got your estimates like you're supposed to do and you don't follow the law, if the apartment's so bad that the damages are more than the $600 that they put down, tenant gets nothing. And that happens a lot, guys. So zero is zero. I suggest to you as landlords and as tenants that you don't want an eviction on your record. So I suggest as landlords you cooperate with tenants that don't want an eviction on their record if they have paid the rent. They're late, but they pay the rent, they give you the keys back. This person's not going to get a decent apartment. They've been there for a year and a half, they get sick, they can't afford to pay the rent. You evict them, they won't leave. If they pay the rent at the hearing or before the hearing and give you the keys back, cooperate with the tenant. Get the eviction off their record, because they're going to have a tough time finding a place. So, but now if they haven't given you the keys back and they don't pay the rent, evict them. Don't take it off their record. But a lot of tenants just, they lose their job, they find a new one, they'll come up with the money, try to be nice to some of the tenants. You know, the city of Cincinnati is, if reading the newspapers, they're going to try to stop a lot of the evictions that are going on. And they haven't passed anything yet, but they will be. You got a pretty liberal city council, and they're going to be passing legislation where it's going to be a lot harder to evict. So you keep up with what city council does, because they're going to try and change the law. Can they change the law? Probably not. It's hard for a city to make a ruling that is not consistent with the state law in Ohio. But they can try and do it, and some of the judges may follow this. They haven't done it yet, but I know several of the councilmen personally, and they're going to do it. Once they get finished with the soccer stuff, they may get into some other issues. Right now they're too tied up. So that's basically covered my outline. I had written this again. Didn't know who's going to be here. I'd written it for tenants, telling what the tenants should do. I think I've covered most everything. As a landlord, obviously, if you're not going to give a security deposit back, you've got to take pictures. Tenant's going to take pictures. You've got to take pictures. Pictures are worth 1,000 words, and if it shows how bad it is, then the judges are going to look at that. So take a lot of pictures, get your estimates, send a letter to the tenants, certified or not, I don't know. The law says it's assumed if you send ordinary mail to the address that the tenant gives you, and you don't get it back, the law says it's assumed that the tenant received the letter. Go ahead.
You mentioned pictures. What's the
Right.
best way to present the pictures in a court case? Should you do them?
Well,
Print them out?
print them out, because these magistrates don't want to look at phones. They'll take your phone. That's what they'll tell you. They'll take your phone and they'll keep it until the case is over. So print them all out, right? Yeah, print everything, and I suggest if you're trying a case, make exhibit books. Yes.
So is the tenant responsible for rent if he stays past the 30 days?
Sure.
He's responsible for the next month, right?
Correct.
Okay.
Correct. Try and collect it. Yeah, yes.
Will there be another class like this, sir?
If that's the library. The library is sponsoring this, not me.
Okay.
And the library is sponsoring this, but you won't see me. You'll see somebody else. Yes.
I was going to ask that I have the 5 or 6 tenants from Section 8. The Section 8 is paying their rent monthly.
Right.
But the tenant is responsible for water bill if they don't pay. Just like I have a tenant that haven't paid the water bill for 5 or 6 months, it's above 500, 600.
Yeah, you can evict that tenant. That's part of the lease. It's a breach of the lease.
Yeah.
It's a breach of the lease.
Then 3 days notice or 30 days?
Well, that's I think to be safe, you probably need a 30-day notice. It's not rent. It's not covered under the statute. I think some magistrates would say it's part of the rent. Some magistrates may say it's a 3-day notice because it's a serious breach of the lease. But there's some magistrates who are going to say in Hamilton County, no, you need a 30-day notice. So you're safer doing a 30-day notice.
Thank you.
You have a card?
I've got cards, yes, but you got my address and name is on there. So, I've covered everything. So any questions? I'll be. Yes.
To take short time. If you bring a tenant and show him the apartment and he likes it, can you put the in lease as it is?
You can put in your lease that he accepts as is. Yeah, you can put it in. I don't think. Yeah, that's not violation of the law. But you've got obligations under the law that you've got to. So your as-is clause doesn't mean that you don't have to follow your obligations under the law. So you can't get around your obligations under 5321.04 by saying as is. You can get around maybe you didn't paint this and he's accepting it as is. Yeah, I think you can do that.
Thank you.
So.
Asking on the tenant side, is it legal for our like landlords to continue to charge like for application fees? Like he has a new unit going up for rent and then they collect a lot of application fees even though they've already accepted someone else and signed the lease and everything?
I'm not sure your question. Is it legal for him to charge charge an application fee?
Or continue to collect application fees while already accepted someone else to rent the unit?
Obviously, he can't accept 2 application fees for the same unit. Can't do that. He can if he's approved a tenant, he obviously can't charge another application fee. If he's not approved a tenant, he could charge an application fee. Yeah.
Okay.
Yeah, because he's doing a background check.
And when you're saying approved, is that like the lease sign or just, when they say like, yeah, I'll rent to you, or is it, it's kind of looks kind of like a gray area, but.
I don't know the answer to that question. I've never had that come up. I really don't know. I can tell you that if you can prove the landlord is taking application fees and they've already leased the apartments, I can tell you the court is not going to be happy with that person. That's almost theft. That's just about theft. So. Any other questions? Well.